On December 27, 2019, he picks up this burglary. Then you would have thought something clicked with that. But then what ends up happening? He picks up the violation of the court order or bond order. Then after that, you would think something would click. Hey, I just got arrested, because I know he would have gotten arrested on that and made bond.
Welcome to the Court of Justice.
Calling 2020 CR 2993 and 2023 CR 043W, State of Texas versus Adrian Soto. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Dave Winter for Mr. Soto.
Are you Mr. Soto? And cause number 2020 CR 2998. You enter plea of no contest to burglary of a habitation with intent to commit assault. According to the plea bargaining agreement, punishment is to be assessed at 8 years in the prison, and the state is opposing your application. And cause number 2020 CR 3661, you entered a plea of no contest to the offense of assault, bodily injury of a security officer. According to your plea bargaining agreement, the state is requesting that punishments be assessed at 8 years in the prison. They're opposing your applications. Have both parties had a chance to review the PSI report, state? Defense?
I have, Judge.
Any objections to the PSI report, state?
No objection.
Defense?
No, Your Honor.
All right, any witnesses, state?
None from the state.
Defense?
No, Your Honor, aside from the letters that I provided to the court.
All right, and for the record, the court has reviewed the letters that have been presented. The court will hear arguments, state.
Your Honor, based on the defendant's criminal history, he did pick up these felony cases as well as multiple misdemeanors that are also pending involving the same family.
At first glance, this may seem like a routine sentencing hearing, but listen closely. The prosecution isn't just asking for prison because of one offense. They're painting a picture of repeated decisions that, in their view, show an escalating pattern. Whether the judge agrees with that interpretation could determine everything that follows.
The defendant's conduct is escalating and continues to terrorize the family, including the complainants on this case, as well as her brother, her children, and her mother. In the burglary for habitation, burglary to a habitation case, the defendant's alleged to have entered the house through a open window, or through an unlocked window, and grabbed the child from where he was sleeping at 3 o'clock in the morning. He's shown a disregard for the safety and welfare of the complainant as well as the children in the household. And it's the state's fear that if the defendant were granted probation, he would continue to contact the family and continue to violate any no contact orders that would be entered. I believe that the only way to ensure the safety and the welfare of the complainants are to sentence the defendant to the prison.
Defense?
Judge, I reviewed the PSI and also talked to Mr. Soto this morning regarding the impact statement that's provided in the PSI, and I've asked him, since this incident, have he had any contact with the complainants? Since the incident, he stayed away from them. He does have 2 children with the young lady. He hasn't seen the children because of this incident, but he has not gone around them or their household. So I think he's shown that he can stay away from them. I don't think he needs prison to stay away from them. Since he's been on bond, since these cases have been pending, he stayed away from that family. Also, Judge, if you look at his prior history, he does not have any convictions for misdemeanors or felonies. He's 25, he is working. He has support. He has family members here in court with him this morning. He had the letters that were provided to him. I think when we pled on the case, Judge, the court asked him if he was experiencing any substance abuse issues at the time of the offense. He was truthful with the court. He said, yes, Judge, I was under the influence. I also asked him this morning if the court did testing, how he come up. And he explained to me he would come up negative. He has not been using any type of substances since he's been on bond, since these cases have been pending. He is working. He's working as a painter. He's not on child support for the children, but he is willing to place himself on child support so he can start contributing to their well-being. Also, Judge, the TAP evaluation, I noticed that it is recommending inpatient treatment. if the court did grant his application for deferred, we would ask the court to first see how he does in intensive outpatient treatment, because he's shown that he can stay drug-free. But I do think he would need some assistance with that. Even though he's been doing it since he's been on bond, we would ask the court, if the court did grant his application for deferred, to place him in intensive outpatient treatment prior to placing him in inpatient treatment. He accepted responsibility for both offenses. He pled to these cases, and now we're here before the court asking the court to grant his applications for deferred.
All right, so this is the court's issue. And not really an issue, but these are things that I think of. All right, so he has a felony offense, and I'm assuming this is being taken in consideration. The violation of an order, protective order. That's from December 31st, 2019. The burglary that he pled to is from December 27th, 2019. So let me go in order. So he has a continuous violence case that's December 14, 2018. I'm not saying it's true because nobody pled to that, but that's what he's charged with. Then after that, you would think something would click. Hey, I just got arrested, because I know he would have gotten arrested on that and made bond, and he would have gotten an attorney. So you would have thought that something would have clicked with that. But what ends up happening is on December 27, 2019, he picks up this burglary. Then you would have thought something clicked with that. But then what ends up happening? He picks up the violation of the court order or bond order or protective order on December 31st, 2019. And you would have thought that it would have been like, hey, I need to be on my P's and Q's because I picked up all these felonies. I understand relationships, and sometimes people don't love each other anymore and they have children and they got to make it work for the children, or they got to stay respectful to each other because they got to raise children together. And as everybody know, even though people say, we only need to be with each other for 18 years, but people know sometimes you need to be with certain children till they're like 25 or 30. I understand that. But then what ends up happening? He ends up picking up another case that he pled to, which is the assault case, on September 17th, 2022. So he has some issues. And I don't think that probation at this time is appropriate for him. Is he on GPS?
He is, Judge, and since he's been on GPS, he has not violated the GPS.
Oh, because he's on GPS because of this. And I'm not the judge who gave him probation for continuing to pick up cases. Some other judge did that, and the only thing I came back to do was probably add the GPS so that everybody would know where he was. So I'm not inclined to give him probation. I'm not going to give him probation. I'm going to sentence him, and I will retain jurisdiction. So in cause number 2020 CR 2998, court will find you guilty. Court will sentence you to 5 years prison. Give you credit for any time served.
This is the legal turning point of the hearing. Rather than viewing each charge in isolation, the judge is examining the sequence of events. Her concern is whether previous arrests, court orders, and opportunities to change behavior actually influence the defendant's choices. That pattern is becoming the deciding factor in whether probation remains appropriate.
There's a $1,500 fine. Time and money will run concurrent. This will run concurrent with 2023 CR 0463W. Take in consideration 2022 CR 3661, 2021 CR 3086, night mag number 679462. The following county court cause numbers: 634960, 6048888, 630200, 634,987, 634,989, There's an affirmative finding of family violence. There's to be no contact with Augustine Olvera, Olvera, Elvira Olvera, Galilea, Gaillia, Olivera, and John Mello, Mellow. Give you credit for any time served. And that cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And cause number 2023 CR 0436W, court is finding you guilty, sentencing you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2020 CR 2998. There's to be no contact with Bentley, Bentley, Beer, Ber, Garden. Court will give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney?
Yes, ma'am.
Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. I'll retain jurisdiction.
Both cases, Judge?
Yes. Sometimes, you know, it is about it's always about rehabilitation, but it's also about protecting the community, and it's also about punishment. Sometimes people think the justice system isn't about punishment, but really, all these cases, there's an air of punishment involved, but hopefully rehabilitation. I know you probably think this is the end of the world. I came in here, I'm going to prison, but you're young, you still have a chance to get your life together. Please don't go to prison and get a bunch of tattoos, because you're clean shaven now. Please let it stay that way, okay? All right, thank you. Is calling 2024 CR 012861, State versus John Calvin Berry. Could I have parties announced for the record for the state defense?
Renee Munoz.
And are you Mr. Berry?
Yes, ma'am.
And counsel, are there applications in this case?
Yes, Your Honor, there are.
All right. Ms. Abrams, there's an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Berry, did you review the document entitled Application of Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor. On the pleading count 2, the prior conviction date should read 22nd of November 2022 rather than 22nd of January. State waives to have the information. State waives to
Defense has no objections to those changes being made now.
All right, do you understand the state is asking that a substantive change be made to the indictment?
Yes, ma'am.
Do you understand that your attorney has 10 days to prepare for trial?
Yes, ma'am, Your Honor.
And are you waiving those rights, and do you wish to proceed?
Yes, ma'am.
And the state is proceeding only on count 2. Did you review the documents entitled Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Did you understand you're charged with evading arrest detention with a previous conviction as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am. Yes, ma'am, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am, Your
And
Honor.
did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, ma'am, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at 2 years in the state jail facility. The state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am, Your Honor.
Defense is at the plea.
That's correct, Judge.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be no contact with Target and Academy Sports and Outdoors, and a referral to felony drug court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence. Did you review the waiver? Any objections?
No objection, Judge.
Did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am. I understand, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
All right, state, they say that there is a restitution amount in the police report. Well, let me take that back. Is there any restitution from the Target or Academy?
Your Honor, merchandise funds recovered.
That is our understanding as well, Judge.
All right, anything else you wish to say on behalf of your client?
Your Honor, we're respectfully requesting that the court follows plea bargain agreements. My client is not without his struggles and faults. He has been battling some issues related to mental health as well as substance use. He is willing and able to make a change, in my opinion, and will work any programs that the court deems suitable as far as treatments or other conditions of community supervision. He did want me to ask the court if he could be allowed to make the appointments out of custody, as he has a place to live, and he stated that he would definitely make all appointments as scheduled as far as a potential TAP or mental health evaluation. I notified him that would be up to the court, but aside from that, Your Honor, we're just requesting that this honorable court follow the plea bargain recommendation.
All right, do you have any children?
Yes, ma'am.
What are their ages?
I have one daughter. She's 14.
All right, and does she live with you or no?
Not right now.
When's the last time you had contact with her?
Just right before I was incarcerated.
And how often have you been using?
Just like once or twice a month.
All right, we're not here for once or twice a month of using. People don't pick up, these theft cases and running away from the police for once or twice a month. And in the police report, it said that you had drugs on you. So again, how much are you using?
Every day.
All right, so why are you being dishonest?
I was thinking about the visit. I'm sorry. I was,
All right, so what drugs have you been using every day before you were taken into custody?
meth.
All right. And how far did you go in school?
I had my GED.
All right, this is what the court is going to do. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years, and state your excuse. In custody, the following is to occur: a referral to felony drug court, TAP evaluation, MIC evaluation, follow TAP results. There's to be regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution. I'm going to order the theft course. Once he completes that, 100 hours be deducted. And then there's 100 hours if he decides to better himself through a trade school, or it counts if there's something else that he does to better himself, just bring it to the court and I'll consider that as community service hours.
Yes, Your Honor, what do you think?
Otherwise, you're going to end up picking up trash off the side of the street.
I understand.
There's to be no contact with Target or Academy Sports and outdoors. There's going to be field visits 1 time per month for 8 months. Probation, is there anything else? I'm sorry. Oh, thank you. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. Anything else, probation? Is there anything else you need from the court in order to be successful?
No, ma'am, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, Your Honor.
And I'm sorry, probation, there's to be no unsupervised contact with minors. All right, we can go off the record. In this court, in order to be successful, communication is key. If there's an issue, let your probation officer know. If you feel like you're going to use, let your probation officer know, and we'll take it up. If for any reason you feel as though they're not addressing your issues, you can always come back to court. You understand?
Yes, ma'am, Your Honor.
All right, good luck to you.
The courtroom fell silent as Judge Stephanie Boyd looked at the defendant, a 25-year-old father who had just pleaded for a second chance. But she saw something he didn't want to admit, a terrifying pattern. He broke into a home at 3 a.m. through an unlocked window and snatched a sleeping child from their bed. Days later, he violated a protective order, and 4 years later again, he was back with another assault case. You would think something would click, Judge Boyd said coldly, but it didn't. The defense begged for probation, pointing out he had stayed clean and stayed away from the family. But Judge Boyd wasn't buying his sudden change of heart. She destroyed his freedom right there in court, handing down 5 years in prison. No probation, no more chances, just a stern warning. Don't come back with tattoos on your face. Your life isn't over, but your excuses are.